Hey everyone, thank you so much for joining our webinar today on mastering the eviction process. We're joined by real estate and eviction attorney Phil Revah, who's going to give us some legal tips every property manager needs to know. Phil is licensed to practice law in Florida and Washington, D.C., and is the founder of Revah Law. His firm focuses on real estate, landlord-tenant transactions and laws, evictions, and much more. And of course, as a legal disclaimer, the information today is not legal advice. It is only for educational purposes only. It's primarily based on Florida law, and it may vary by jurisdiction, so you should always consult your own attorney for specific legal advice. So without further ado, Phil, thank you so much for joining us today.
Thank you for having me, David.
Phil, start us off by telling us a little bit about yourself and your law firm.
Sure. Yeah. I've been practicing real estate law, specifically landlord-tenant litigation, for over a decade now. Our law firm focuses on basically all manner of real estate litigation, whether it's landlord-tenant, construction, condominium association, closings. We're also a title agency, so we represent clients, buyers, and sellers and underwrite title. And so if it affects the dirt, then our law firm handles it.
I love that. I love that. So let's start off by asking you basically, what are the most common reasons you see disputes and evictions happening in general between landlords and tenants?
Sure. So, I mean, just to unpack this a little bit, my law firm does landlord-tenant litigation in the state of Florida. We do that. We do landlord-tenant disputes, specifically evictions. Although obviously there are different kinds of landlord-tenant disputes, but evictions in particular, we handle them in all 67 counties, and it'll vary. Let me close the door.
Yeah, you're good. Don't worry.
As far as the reasons go for eviction, it'll vary from case to case, but what you see very often is that there's either a written lease in place or the lease is verbal, and the tenant has committed some sort of default under the terms of the rental agreement. Typically, like more often than not, that default is non-payment of rent. And Florida law, specifically Chapter 83 of the Florida statutes, governs what happens when a tenant fails to pay the rent and the procedure that the landlord must follow both prior to filing a case in court and while it's in court in order to get possession of the property back. A lot of people overlook, or a lot of lay people, I should say, don't fully appreciate or understand that the eviction is a lawsuit. Okay, you have to sue for possession of the property. So I get a lot of calls sometimes, people telling me, I heard it takes 30 days to do an eviction, or isn't it true that it takes 20 days and they got to be out? I just want to set the record straight. There's no set time limit or amount of time it takes to get a judgment of eviction. In large part, the time it takes to evict somebody will depend upon the judge you have, whether the tenant is contesting the case, whether the tenant is represented by an attorney, and how diligent and quick your lawyer is moving your case along. Those are the real factors. Now, assuming all of those things happen under ideal conditions and they're moving, as they should quickly, since time is of the essence, obviously, then you could get an eviction judgment from the time you file the complaint until the time you get a judgment. Could be 30 days, it could be less. I'll tell you for the record that the fastest eviction from filing of the lawsuit until obtaining a final judgment that I've ever done was 14 days, and it was contested. So every case is different. And then I'll tell you that the slowest one was probably more than 2 years. Very,
Wow.
very particular circumstances. It was a commercial eviction. They had, high-powered law firm defending the tenants. The point is, the vast majority of evictions take 30 days, give or take a week or two, depending on what happens in the case. And then you have your outliers, if you will, on both ends of the spectrum in terms of the fastest one you could do or the slowest one you could do. And more often than not, the reason for the eviction is non-payment of rent or some other breach of the lease. And depending on the reason why you're evicting the tenant, the reason will dictate what kind of notice you have to give to the tenant prior to filing the case. And if you screw up that notice, you probably screwed up the case. And now there's a real possibility that you may have to pay, if the other side, the tenant, is represented by an attorney, you may have to pay their attorney's fees as the non-prevailing party because they could have a successful defense of defective notice. This happens very often. More often, you know, ve what I've seen many times, landlords will call me and they'll say, "Phil, I've been doing my own evictions for decades, and I've never had a problem. But this tenant gave me a problem." Sure enough, the tenant's got a lawyer. The lawyer is probably like pro bono. He's making all the right arguments about their notice, about why it's defective. And now there's a real risk that the landlord's going to lose and end up paying attorney's fees, which will be a very significant amount if and when they don't prevail. So it's really important to know your reasons why you're evicting, to review the lease and ensure what does the lease have to say about this kind of default, and then obviously know the law in terms of knowing what to provide in terms of a pre-suit notice to the tenant prior to filing the suit. And I probably touched on 100 different topics there. Original
13 of my
your
questions.
your original question was, what do you see most often? And the answer is non-payment of rent, right? I mean, it's like most other things you'd think you can work them out, or if they're super egregious, you're gonna wanna bring somebody in. You're gonna wanna, try maybe look at it, bring a lawyer in, say, no, for example, I'll give you an example. Okay. I represented a landlord who had a tenant that was shooting a tree with his firearm for fun, like target practice. Okay. So you're not going to give the guy a 3-day notice for non-payment of rent and then file the suit, right? You consult with an attorney. This is what this guy was doing. What kind of notice do I have to give to him? And ensure that that notice is properly drafted in a detailed fashion. You give it, you wait the time period set forth in the notice, and in that case, you would give what's called a 7-day notice to quit, meaning you have 7 days from the date of the delivery of this notice to vacate because your tenancy is terminated as a result of the following, unlawful actions A, B, C, D, E, F, G. And then you file suit if they're still in possession once the time period in the notice lapses. So, uh, to answer your question, I'm sure I butchered it, but
No, it was
there-
great. I wanted I
it's
wanted to jump I wanna jump into, like, the payment. So that is what the most common reason we see as well, non-payment of rent. So, let's say someone owes rent on the 1st of the month. It's the 1st of the month, rent doesn't come in. What do you recommend a landlord or property manager should do right away as soon as that happens?
okay. So if the landlord, I'm going to answer this question in a roundabout fashion. If the landlord is going to insist that the tenant be held to the strict letter of the lease and for strict performance, just a moment, please.
Go ahead. This is what happens when we do, live webinars. Business is running as usual, so we'll give them their 10 seconds.
Sorry, go ahead.
Go ahead, go ahead. Yeah, so someone doesn't pay rent, it's the 1st of the month, you're not I mean, I guess you're gonna make an argument, "Hey, if you wanna get get 'em out, you can start going through the process immediately or give them some time to cure and make a payment." So what does it normally entail?
Yeah, so the point I'm making is don't jump into paying an attorney right away, and coming out of pocket and say, this guy hasn't paid me, he's a day late, let's hire a lawyer. Obviously not. That's not what you do.
Right.
So you want to send reminders as often as you can. If you could post them at the property, meaning tape them to the front door, even better. If the tenant is more than a certain amount of time past due, maybe let's call it 5 days, obviously you want to make sure your ledger or your software, in this case, if you're using DoorLoop, of course, is adding to the tenant's ledger that late fee, whatever it is pursuant to the lease. And then, I would recommend, as just as a general matter, if your tenant is more than 10 days late on the rent, meaning the rent is due on the first of the month and it's now the 12th or the 11th of the month, give that tenant a notice to pay or vacate. Um, if you don't, you're going to you're going to create an atmosphere which I don't think is conducive to running a strong, tight ship, which is, well, they're not telling me that I have to pay, and maybe I can hold them off for a little bit longer, and then that snowballs. So that's my recommendation there is maybe not legal, just more practical more than anything.
Yeah. I mean, it sounds like you're saying is try to work with them. Everyone has a story or a circumstance. See what's going on. Communicate is more important than anything else. And if you
For
realize all
sure,
the,
for sure.
yeah,
Yeah, so on that point, let me explain. Obviously you want to work with your tenant wherever you can and have the ability to, but you also don't want to be too lax on how long you wait or how you maintain your tenant ledgers. You want to make sure that that's being done in a very, organized fashion, that it's all in a centralized location, like I said, or software, whatever software you're using. Obviously, a software, everything's in one place is great. In terms of communication with the tenant, always keep all written communications with a tenant in a single centralized location. If an eviction happens, those communications will almost inevitably come up in court, and the last thing that you want is to have communication across four different mediums, email, text message, WhatsApp. Just have it all in the lease. It should state, if you want to if you, the tenant, would like to communicate with us, the landlord, here's how you do it. You do it through our software or through our portal or via email to this one person and nobody else, etc. That's the best way to keep a handle on things, to make sure there's a single centralized portal where the tenant can lodge all of its complaints if they have any, or if there's just basic communication, to make sure it all happens there.
that's a great point. And not to plug DoorLoop so early on, but almost everyone watching this will be a DoorLoop member. So you do
Okay.
have a new feature in the software called the Communication Center, where you can, instead of giving away your personal cell phone number, you can actually get a DoorLoop phone number, a business phone number that you own, where you can communicate and text back and forth and have a written record that never disappears. So
Perfect.
great
That's what you
advice.
want. That's what you want.
Awesome. Now, have you found any tips and tricks for just avoiding these disputes and evictions in general? Is there like a better way to find great tenants that always pay on time? Anything like that that you found? Is
So
it better
obviously,
background checks or anything like that?
yeah. So screening and background checks, probably the single most important thing you can do when it comes to trying to get a gauge on or evaluate what kind of tenant you're about to get, right? Beyond that, if you were to sit down and interview them, I guess you could do that. That would seem like a very tedious, time-consuming, and expensive process. But even even in an interview, you're gonna find out you're not gonna find out everything about the person.
Right.
You may not even find out the truth. So obviously, background checks, screening, tenant evaluation, all of that is super important. It should happen prior to signing any leases with the tenants. It should be thorough, and if you're getting red flags, I could tell you there's a very good reason for it. You might look a tenant up and you'll see 5 evictions in the last 5 years.
Wow.
You should not sign, okay, a lease with that tenant. You're buying yourself a legal problem.
Yeah, 100%. So let's talk about the pros and cons of evicting a tenant. Obviously, the pros are you get them out and you get a better tenant in and you can start collecting rent. Are there any cons to evicting a tenant?
Cons.
Maybe not.
From a legal perspective, it's hard to say that there are cons, right? Because if you've made the decision to file suit, it's because, you've already decided that this particular tenant, on the balance it's way worse to have them than to not have them. Maybe they're costing you money, maybe they're destroying the property, etc. From a practical perspective, I don't know. I think it's clear that when you're doing anything as, if you want to say sensitive, if you will, as an eviction, there are from a business owner's perspective other potential injuries, reputational, for instance, injuries that could happen or could piggyback on top of an eviction, maybe bad reviews, right? You got to be cognizant of all those things. That's inevitable. There's not much you could do there other than maintain professionalism, keep your head up. And then to the extent that there's something that isn't true, just have somebody monitoring reputation, etc. Building for those tenants that do appreciate your business or the services or whatever it is that the landlord is offering them, then make sure to collect those good reviews, maybe have find a way to incorporate them, and that way it'll on the whole balance out when you do run into that occasional tenant that is giving you a problem.
Great. You mentioned earlier making sure to have specific things in the lease agreement. Is there anything specific that everyone should have in their lease agreements to protect themselves?
Yeah. Anything specific? Look, there's a lot you can put in a lease agreement. It's going to depend what kind of house. What kind of is it? A house? Is it a condo? Is it multifamily, single family? Right. So first you break down the kind of property it is. Then you want to figure out what are the property's weaknesses. What are its strong points? Oh, it's been reported in the last 10 years that there's cast iron plumbing. It's a weakness. Okay, so be mindful of that. Draft around it in your lease, and then as far as the actual lease itself goes and just the general provisions, there are many, many general provisions you want in the lease. You want to make sure that you want them incorporated. You want to make sure that all of the maintenance obligations are very clearly and concisely spelled out. You want to make sure that the procedure for reporting an issue to the landlord and likewise from the landlord to the tenant is very clearly and concisely spelled out and has to be strictly adhered to. And then, you also want to disclaim any warranties, any implied warranties, any express warranties if you're the landlord, right? Because there might be some
When you say
implied
warranties, what do you mean? Just to spell it out for people.
there is an implied warranty of there are several implied warranties in a residential lease agreement. One of them is the implied covenant of quiet and peaceful enjoyment,
Okay.
right? So if you own a multifamily property, 3-story building, 12 units, and next door you have a building that you don't own, but there happens to be a family of pyromaniacs living there. So now you have to account for the fact that your tenants are going to be complaining about that neighbor, and you want to make sure that you disclaim any liability, for their any implied covenant of peaceful and quiet. You can't control the actions of a third party, right? And then also there's some case law, and this is not common at all, but I actually always recommend this to this bit of a secret sauce type of thing. But I'll share it with you today, which is that it is not common for a landlord in a lease to have a clause wherein the tenant waives the right to receive any and all notice in the event of a certain kind of default.
Okay.
It's actually been upheld by the Florida appellate courts. So you could actually, there's a freedom of contract. So you could, as long as what you're contracting for isn't illegal, like robbing a bank,
Right.
you could pretty much contract for mostly anything in your lease. And if you want that to include, you know, tenant has to pay a mandatory cleaning fee, which will come out of tenant security deposit at the end of the lease, and they sign off on it, then freedom of contract.
Got it. I think the biggest takeaway I got is there's no one size fits all lease agreement. A lot of people that I know will go to maybe the Florida Bar website and find the standard residential lease agreement and use that for all their different portfolio types. But what you said is very interesting. Every single different type of property, single family, multifamily, condo, you should have customized lease agreements per portfolio type. Is that right?
I think that's right. Yeah.
Awesome.
No, is that not to say that there isn't gonna be, like, 30 or 40 clauses that are standard in most every yeah, of course there are.
Right.
But then you wanna tweak it and tailor it for the particular kind of property you're dealing with and know the strengths and the weaknesses of that property.
So let me get into one of the last topics we wanted to cover here. So I imagine that many people after this will be going to their favorite AI model, ChatGPT, Gemini, you name it. And they're going to say, draft me a lease agreement or update this or update that. What are your thoughts on the legality and, factualness, is it the correctiveness of using AI for these type of things?
Well, I'll tell you right off the bat, there's already been instances of attorneys using ChatGPT to write legal memorandums or for citing case law that turned out to be completely and utterly incorrect, and attorneys being sanctioned by a court for misconduct in just blindly putting whatever ChatGPT gives you into a court file.
Yep.
So ChatGPT is and other AI platforms, Grok, whatever you're using, are extremely powerful tools. And they will give you, with surprising accuracy, very good advice every now and then. I don't even want to say every now and then, more often than not, right? But there will be those instances where it's just wrong or whatever answer you're looking for because you're limited in the question. This ChatGPT, from what I understand, is all about the prompt.
Yep.
So, to the extent that your ability as a non attorney is limited, by extension, your question, the very premise of your question is already going to be off to the wrong foot. So, what I'm trying to say is ChatGPT used by a lawyer and ChatGPT used by a non lawyer, that'll also give you two drastically different results. The lawyer can ask type in a far more narrow prompt and get perhaps an answer that's far more accurate.
Right.
The non-attorney might type in a question whose question, the premise of it is already to begin with incorrect. And then from there lead to a series of other incorrect, assumptions, which could really hurt the landlord. So my advice on the whole about ChatGPT is it's a wonderful tool. Use it, but never rely on it if you're stepping into court. Run it by an attorney. And also, or if you're about to step into court. So, you might say, I have a tenant that keeps flushing wet wipes. You might type into ChatGPT, I have a tenant that keeps flushing wet wipes down the toilet, and I live in Florida, and my property is in Palm Beach County, and I want to evict this tenant. How do I do it? Okay. ChatGPT is going to give you like a step by step. You give them the notice, then you file the complaint, then you serve them, right? But it's not gonna tell you, you know, it's not gonna tell you what an attorney would tell you, which is Florida law requires you to give this kind of notice. It has to contain this kind of language. It has to be set forth in this manner, and it's got to be delivered in this fashion, right? It might tell you that, but if you're not good with the prompt, it'll give you a broader version of that, and you'll skip over it. And that skipping is where the problem is, because that's where you could
Right.
lose the case.
Right. Right. Got it. Okay. Awesome. I am seeing some questions in the chat over here. So I want to just cover one and then we're going to open it up in a few minutes for everyone to ask questions. But probably one of the last questions we'll ask you and then we'll open it up for Q&A is walk me through the standard, typical, average process and timeline of a normal eviction where the tenant did not pay rent.
Okay. Uh, Tenant fails to pay the rent. Uh, First
First
thing
of the
you
month.
do,
Right.
First of the month. Come the 5th of the month, let's say lease provides for a 4-day grace period. Come the 5th of the month, they still haven't paid, a late fee is assessed and added to their ledger. That doesn't mean the rent is due on the 5th. It means it's due on the 1st. It's just considered late and incurs a late fee by the 5th. Come the 10th of the month, maybe sooner, maybe later, depending on the preference of the property manager or the landlord, you give a 3-day notice to pay or vacate. That notice will contain something along the following language. Dear notice, from landlord to tenant, landlord's address, landlord's name, tenant's address, tenant's name. You are hereby notified that you are indebted to me in the sum of X amount of dollars for rent and use of the premises located in whatever county. You have 3 days, not including weekends and legal holidays, to pay or vacate. To wit, on or before this day, you must pay or vacate. If you fail to pay, you fail to vacate, we're going to file an eviction lawsuit against you. You wait that 3-day time period. They may pay. Most often they don't. If they don't, after those 3 business days are up from the date of the posting of the notice, and I want to stress this, always better to post a notice, never mail a notice, a 3-day notice to pay or vacate. That's not recommended. People do it. If you mail it, you have to add 5 business days. You have to confirm receipt. The tenants deny that they ever received it. Don't mail notices. Always have them taped or posted to the front door with a picture proving the posting. Now, that 3-day notice has to contain specific language under Florida law. That language is contained in Chapter 83 of the Florida statutes. You could just Google it. It's there. There's also Florida bar forms for a 3-day notice. You tape it to the front door. The 3 days elapse. There's a procedure what happens if the tenant wants to make a partial or full payment. But setting that aside, like let's say if they pay in full during the 3-day period, your grounds for evicting them under that 3-day notice have now disappeared because they have cured within the time period required by the notice. So don't take the money and then go file a suit because you're going to lose, and that is going to be problematic. So assuming they don't pay in full, let's say they make a partial payment, you should either tell them, A, I'm rejecting your partial payment, or B, to the extent you want to make a partial payment, you can, but you're going to have to put it in the court registry once I file this eviction against you, because that's what the law says. You either reject the partial payment, or to the extent that they may want to make one, you tell them, we're still moving forward with the eviction. We're not accepting a partial payment. You'll have to put that money into the court's registry once we file the suit. So that 3 days is up. You file the suit. Once you file the suit, you get a case number and a summons issued by the clerk of the court. That means that the tenant is being summoned in Old English to come to court and file a response to the complaint for eviction based upon non-payment of rent. They have 5 business days from the date that they are served to do so. A tenant under Florida law doesn't need to be personally served with a copy of this eviction summons and complaint. In fact, the process server under Florida law can attempt to personally serve, meaning personally hand them the court papers, 2 times, at least 6 hours apart. If after those 2 attempts, a minimum of 6 hours apart, the process server is unable to personally serve, then the process server can post a copy of the summons and the complaint to the door. It's kind of like in Old England, in the medieval times, where if they wanted to post a notice to the town or its residents, they would go to the town square, and somewhere in the middle of the town square, there'd be a giant something, and they'd take a hammer and a nail, and they'd unscroll their scroll, and they'd nail it to the dog, and they'd say, notice to everybody present, right? So this is literally, we're getting that particular with it. And why can we do that with evictions and not other lawsuits? Like, let's say basic lawsuits where you're suing for just money. Well, because in an eviction, there's a special thing going on where there's a legal fiction where you're suing the property too. You're not really suing also. So you can get away with serving by posting to the door if you've made 2 attempts at personal service, even if they're not there, because you're suing for possession of the property, not just the person living in there.
Got it.
And so the law intelligently accounts for tenants who are just going to close the blinds and not answer the door. Okay, so you can post, they have 5 business days to come to court or to hire a lawyer to come to court and file a response to the eviction complaint. Okay, their response, it could be one of 2 things. It could be, I admit I owe this rent. It could be, dear God, the roof is falling and I have rats and bed bugs under my bed. It could be, or it could be a whole host of things, right? But the point is, the law requires them to do one of two things in answering an eviction when you sue for non-payment of rent, when you sue for eviction based upon non-payment of rent. That is
Yep.
either A, deposit the rent that says it's owed, that is alleged to be owed in the complaint into the court registry, or B, if you're not going to deposit it, you have to file a motion to determine the rent, asking the court to determine what rent should be deposited in the court registry because there's some maintenance issue that you put the landlord on notice of in writing
Mm,
that the landlord never attended to.
got it.
Hence the importance of having, and that happens all the time in evictions. You sue for eviction, they owe like 5 months of rent, they come to court and they say that everything's wrong with the property. Meanwhile, they're still living there. So if you have a centralized location and your lease says all communication has to go through this medium, and you have this centralized medium of communication with your tenant, and there isn't a single message, from your tenant to you saying, come fix this, come fix that, then you're going to show the judge, here's the lease. Here's where it says they have to communicate with me in this fashion. Here's where they never communicated with me in
Wow.
this fashion. So
Wow.
the motion to determine the rent should be denied, and your honor should require that this tenant deposit the full amount that is alleged in the complaint into the court registry. Now, under Florida law, if you don't deposit the full amount of rent alleged in the complaint in the court registry or file a motion to determine rent with supporting documentation, then you waive the right to bring a defense to the eviction action, and the court has no discretion but to enter a judgment for possession of the property in favor of the landlord. Once the judge signs that piece of paper, the final judgment that says landlord, property owner is entitled to possession of the property, they got to get out in that moment. Now, they never do, as a practical matter, they never do. So then you got to get the sheriff involved. So the judge will order the sheriff, again, going back to Old England, okay, via what's called a writ, WRIT, a writ of possession. And that is a command from the judge to the county sheriff saying, Sheriff, I entered a judgment of eviction against this tenant. They refuse to vacate. Please go to the property, forcibly remove them after providing 24-hour notice, and put the landlord in possession of the property. And from that point forward, when the landlord meets the sheriff to do the removal, at that point, the landlord can change the locks, and any property,
Okay.
personal property that is located within the unit or whatever it is, can be removed and thrown out onto the property line without liability
Wow.
to the landlord or the sheriff. If you were to go into the property post final judgment without executing a writ and throw their things out, tenant could sue the landlord, post in a separate suit for conversion or for the unlawful, dispossession or conversion of their personal property. Very Sometimes we do evictions even though we know the tenant isn't actually living there, but they've left their things behind just so that we
Wow.
can retake possession and throw their things out so that our clients, don't incur any liability.
Got it.
And I'll give you another anecdote. I'm doing a case right now where the tenant moved out, told the landlord in writing she's completely out, and then sued the landlord a month later, claiming that the landlord took $25,000 of cash she left in a drawer. And there's nothing, the whole lawsuit is hocus pocus. My client, the landlord, has come out of pocket tens of thousands of dollars defending basically what I believe, and what obviously he's telling me, is a fake lawsuit about the supposed theft of $25,000. Had he done an eviction and executed the writ, the case would be over because we'd be able to dismiss it. But
Mm.
lo and behold, he didn't do that. He filed the eviction. Midway through, she said, I'm leaving. So he let the eviction languish and flounder, and that was that. Now he's dealing with another lawsuit.
Wow. You live and learn. So what you mentioned before, is that referred to as self-help eviction, where a landlord will change the locks, turn the electricity off before they're allowed to, and that's really bad, obviously?
Yeah, so I always think in my head, I always think of like, so it's chapter 83.67 of the Florida statutes talks about landlord's prohibited practices, what the landlord is prohibited from doing. And the funny way I like to remember and associate things with this statute is I always picture this scenario where it's like 1930 somewhere in Brooklyn, New York, right? And again, I'm only barred in Florida. And your tenant hasn't paid the rent. So, the Italian mob shows up and they've all got baseball bats and one guy has a chainsaw and they're there to cut your door out, cut your electricity, cut your water until you decide to pay the bill or pay it on the spot, right?
Yeah.
Obviously, that's illegal. We're a country of laws. You can't take the law into your own hands. Don't shut off the utilities or any utilities or bar access for the tenant to the property. If you have an issue like that, get a lawyer, go through due process, the court system, get a judge to agree that you want to do all those things. Don't do it on your own. Because if you do, you can be sued for 3 times the monthly rent or the tenant's actual damages as a result of the lockout, plus attorney's fees and costs. That's chapter 83.67.
Wow. Okay. Do not do that. Okay. Awesome. So we have a lot of questions that we're going to answer soon in the chat. Thank you everyone for the patience. So I want to end with two last things. Phil, talk to me about your law firm specifically. There are people asking if you could represent them. So your law firm only handles real estate and eviction cases in Florida or also DC?
Okay, so we don't do any landlord-tenant litigation or work in DC, only in Florida and in all 67 counties in Florida. So, I like to think of ourselves like the ticket clinic for evictions. So we do them statewide and not just evictions, also, well, sometimes I shudder to tell this to all the landlords maybe present, but sometimes tenants will call me and say, my landlord took my security deposit and didn't send me the required notice under Florida law. Can we go after him? And I say, absolutely. That's low hanging fruit.
Wow.
If the landlord doesn't strictly follow the procedure for making a claim on the security deposit, lawyers love those cases. I just had a case. I'll just tell you very quickly. I think everybody should know this, especially
Yeah.
the landlords. Landlord took the deposit. 34 days after the tenant moved out, he sent a letter. We reached out to the landlord. We said, hey, you had 30 days to do this, not 34. Please return the deposit. You've forfeited the right under the statute to make a claim on the deposit. Landlord says, I don't care. See you in court. Okay, sure enough. We sue him. We go to court. We win. We get a judgment for the full deposit amount, which wasn't that much. It was like $3,000. But my attorney's fees were $24,000. Okay. So now the landlord didn't pay my judgment for 24,000, didn't pay my client's judgment for 3, and we got a break order and sold the landlord's $450,000 condo at a sheriff's sale to satisfy our judgment, and it sold for $47,000. Now the landlord literally lost his property because they wouldn't give the tenant $3,000 back, and they wanted to get smart and play hardball to the point where because we knew they had this asset and we can force a sale of this asset to pay our judgment, that's what we did. I mean,
Wow.
frankly, it's a tragedy. So, yeah, landlords should be careful.
Yeah.
To
Yeah. Yeah.
let
Always consult. Always consult. Okay. So that's an amazing story. If someone needs your help in Florida for a case, how can they contact you? Go to your website and submit a form?
Absolutely, that's the best way to reach me. Revalaw.com. There are several contact form submissions on there. They give you the ability to, and we have a software that tracks. If you call our firm, the length of the phone call, you have an opportunity to put your name, number, email, and a description of your case, and I get it all via email. And we typically handle those almost day of.
That's great. Okay, awesome. So, Phil, thank you so much again. Phil is very generous to stick around for some questions. But before we do open it up for questions, you can keep submitting them in the chat. We see them. I'm going to invite Brian from our team here at DoorLoop just to give you a quick overview in DoorLoop of how you can protect yourself in the event of an eviction, talking about a lot of things that Brian just covered. It's going to be a few minutes. Then Phil will end off with a Q&A. So, Phil, we're going to remove your video for a second. and
Sure.
bring Brian in for a few minutes just to cover those things because I see some questions about DoorLoop in here. And then we'll bring you back in for questions. Cool. So, Phil, stick around.
Sure.
Thanks.
All right. Thank you, David and Phil. I'm sure that everybody got some useful information out of that, and it'll have its value as you guys are going to be using DoorLoop to kind of help you out with some of the features that they spoke about today. So my name is Brian. I'm a customer success manager here at DoorLoop, and I'm just here to quickly walk you through some of the features that Phil and David spoke about earlier that will assist you with protecting yourself during your eviction proceedings. All right. So first and foremost, one of the things that Phil talked about earlier today is ensuring that you are screening the prospects that you plan on having filling those vacancies in order to make sure that you can kind of prevent getting to the point of eviction proceedings, right? And the very first thing that I will show you guys is that we have the ability for you to set up rental applications, right? The bottom left of your main DoorLoop screen, you can go ahead and click where it says settings. And if you scroll down, you will notice that you have the rental applications feature at the very bottom. Heavily recommend for you to go ahead and fill this out. Even if you currently have vacancies, if you don't have vacancies, it's better to have this set up from the jump. That way you don't have to be setting it up later on or scrambling once you do have vacancies. So on here, feel free to customize the rental application entirely to your liking. You have the ability to have certain areas work to your advantage here. So for example, under residential, you can go ahead and ask for landlord information. That way you're able to contact their previous landlord, see the kind of relationship that they had built, what type of tenant they really are, something that maybe the actual reports can't show you on paper. You also have your opportunity to create questions in case you realize that the actual rental application itself isn't specific enough. There may be some states where you can ask for certain questions, other states where you can't. So feel free to look at the laws and regulations of your state, and then feel free to customize the rental application to your liking. Now, once you have customized your rental applications and sent them out, you have the ability to view them, right? So on the left-hand side, you will notice you have a leasing area, and on here, you can jump into your rental applications tab. On here, you will notice that you have several different applicants if they are starting to come through. Now on here, I'll go ahead and use one that I have at the top of my head as an example. Here I have James, and James is somebody that I screened. And as you notice on here, not only are you able to view the actual rental application that was filled out, so pretty much all the information they put on there, but you can also view the reports that TransUnion pulls for you. So in this case, as you can see, you're able to view the credit, criminal, and eviction history reports for that specific prospect. Now on here, just to give you guys a quick glimpse into it, but DoorLoop, or TransUnion better said, allows you to pull their credit report so you can view information of this sort on here. As I scroll up and pull back, you can view a criminal report on here. And I use this specific prospect as an example because on this one, we made it seem as if they have a criminal report. That's something that should be reviewed or looked into. So as you can see, if you scroll down, you will notice that they have a criminal history on here, and it's something that you can keep an eye on in case it's something that you do potentially value as whether or not they can be your tenant or not. Right. So here in this case, I have somebody that had some criminal records, so you can see what they've done, everything of that sort, and actual dates on there and all that kind of stuff. And you can also view if they've had any issues relating to evictions on here. All right. Now, moving forward to another thing that Phil was talking about earlier, please ensure that on your actual lease agreements that you plan on sending out to your prospects or to your future tenants on here, ensure that you have clauses in there that clearly state what the process is when somebody doesn't pay their rent on time, right? So ensure that you're putting on there that rent is due, let's call it on the 1st. Late fees will be applied maybe 5 days after, 3 days after, 10 days after, whatever you want. And eviction proceedings will start after X amount of days, stuff of that nature. That way they've signed off on that lease agreement and it protects you, because when you take it to court and you actually want to show the judge, hey, this was my clause, it clearly states it on the document. Now, how can you grab those terms and put them into DoorLoop, right? Well, first and foremost, the actual lease agreement that you go ahead and draft up with all those clauses and everything of that sort, you can actually use DoorLoop to send out those electronic signatures. So on the left-hand side, under communications, which there's a couple features on here that we'll talk about, you are able to actually set up signature templates for your lease agreements. So you can go ahead and set up whatever templates you'd like. Just to show you real quick what it would look like. On here, if I open up a template, you can see that I have my lease agreement on here, and I'm able to go ahead and pull in all the fields that I would like myself as a user of DoorLoop or the property manager, property owner, and all the fields that I would like the prospects or tenant or tenants, if you have multiple, to actually sign off on. So ensure that you draft up your document to be exactly the way that you want it to be, and then you can upload it into DoorLoop so you can send out that lease agreement electronically. If you do send it out electronically, you will not only be able to track who has actually signed off on it or not, but you are also able to track, you're also able to save that document. When everybody signs off or all parties involved sign off on the actual lease agreement, everyone involved will receive an email with a copy of that lease agreement, and you are able to store it within DoorLoop, and you can even go as far as storing it in DoorLoop on your tenant's file, and you can share that file with them on the portal so they can view it on there as well and have access to it. Now, how would you be able to set up the actual late fees, right? Under settings at the bottom left, scrolling down once again, you also have your fees settings. So on your lease agreements, you should be stating what return payment fees there are, what late fees there are, and you can have DoorLoop actually automate that process for you. So you guys don't have to worry about manually doing this or keeping track of it on a paper, on a spreadsheet, whatever, of the fact that this person hasn't paid over an extended period of time and they should be getting to an eviction proceeding, right? At this point in time, DoorLoop can automate all that for you, and you can just see where they are in terms of actually making payments. Is this somebody that could potentially, need to go to court, whatever the case may be. Now, if you are in court and you need some proof to show the judge, hey, this is the payment history for that specific tenant. Here's the proof that I charged them on this day and they haven't paid since then. Here's a list of all the payments that they've had. Easy enough. Within DoorLoop, you got your leasing area, you got active leases, and under active leases, you can go ahead and jump into whichever lease you'd like. I'll go ahead and jump into one just as an example on here. And when you jump into a lease on here, you can go ahead and jump into your transactions tab. And on here, you can view all the charges and all the payments that have been made by that specific tenant. So on here, you're able to view a list of their ledger, and this is historical. So you can see all the way back to when they actually began in DoorLoop with you. And it's as easy as just clicking export statement over here on the right. And when you click export statement, DoorLoop will go ahead and create a PDF file that you can go ahead and download or even print out and hand over to a judge with proof of the payment history for that specific tenant. All right. And lastly, one of the things that Phil mentioned as well earlier on, you have to make sure that all communications that exist between you and your tenants is done strictly through DoorLoop. Now, how can you ensure that that happens? Of course, you want to be sure that you adopt the tenant portal or make sure that your tenants are adopting the tenant portal. And on the left-hand side, you will see here that under your, communications area, you're able to manage all the communications that your tenants send you. So DoorLoop has two types of communications that you can actually use on here. Your first one is one-way communications, which are the announcements feature that we have on here. So when you click on announcements, you're actually able to send out a one-way communication in bulk to all your tenants, to only some tenants, to only one tenant, as specific as you'd like. And these can be sent out through 4 methods on here, which I'll show you right here, through email, text message, voice message, or an announcement on their portal. And you can mix and match or do all of these at once. So DoorLoop tracks the communications that you send out of this sort, and also the rent reminders and automated communications that we do. Under your communications tab on the left, you're actually able to view a communications log. So on here, you're able to keep track of all the notifications that have been sent out across the board to your tenants and messages, announcements, everything like that. And you're also able to track if it's been sent to them, delivered, if they've seen it and opened it, and if there's a link on there, if they've actually clicked on it. So this is also your proof that this person has been receiving these sorts of communications. Heavily recommend if you can get emails from your tenants, even better. That's the best way for DoorLoop to be able to track the status as to whether they've opened it, whether they've clicked the link, so on and so forth. Now, if your tenants would prefer to communicate with you via text or something of that sort, we also have that feature and heavily recommend that you use it. Again, coming back to your messaging feature, you have the option to create SMS messages on here. And you can text back and forth with all your tenants that you have in DoorLoop. So on here, whenever you go ahead and text with people, or even if you send out announcements, whatever the case may be, you can view all the people that you've actually texted, and you're able to see a list of all the messages that have gone back and forth since you've began using DoorLoop to actually communicate with them. And you're also able to filter out if you want to see just text messages that you've sent out or just announcements that you've sent out. So you can view a list of both. All right. But at the end of the day, again, this is all organization, communication that needs to be established with your tenants. And just to show you how easy it is for your tenants on here, if I was to just go ahead and jump into this list of tenants on here, I can go ahead and click on the three dots. I can jump into log into portal, and we can actually see what they see on their end. But it's very easy for your tenants to use this portal. They can view all the announcements that you've been sending out to them, the one-way communications, and the two-way communication would be directly to their phone, because it's an actual text messaging feature. And of course, you have your area within the communication center where you can keep track of all those messages that you've sent back and forth. All right. But yeah, very easy for your tenants to actually use the portal to actually keep track of all the messages that you've sent out to them. They can also view their ledger. So there's also proof on their end of that. And they can also view any documents that you've decided to share with them. On here, you have your My Files area. So if you were to upload a copy of their lease agreement onto their file, you can go ahead and specify that you would like to share it with them. All right. And last thing that I wanted to show you guys, very important, also to protect you from any sort of eviction or during eviction proceedings, better said, just a very small toggle on here. On the left-hand side, if you jump over to your leasing area and you jump into active leases, if you are currently going an eviction proceeding with one of your tenants, just make sure that you jump into the lease that you'd like. So I'll go ahead and jump into this one to use as an example. And at the top right, you're going to notice you have a settings tab. Just go ahead and click on that. Select eviction status on here. And just make sure that you enable this toggle. By enabling this toggle, not only do you label that lease as undergoing eviction, but it also disables online payments. So therefore, your tenants can no longer make online payments to you. And during eviction proceedings, that's usually the case. Because you are in an eviction proceeding, they cannot make payments to you, and therefore you can't go through with the actual eviction. All right, and you check off this box, you click save. So now that lease, when you look at your active leases page, will be marked as a lease that's undergoing eviction, and you'll see it here. All right. Aside from that, I'll go ahead and hand it back over to Phil and David. Thank you guys for hearing me out on here, and I'll still be one of the moderators in the chat, so please feel free to ask any questions regarding what I went over today. But aside from that, I'll go ahead and pass it off to them.
All righty. Thank you so much, Brian. That was great. Phil, you could turn your camera and audio back on now, and we are going to open it up for questions. So all your legal questions, you could ask Phil. He's going to stick around for a while. And if anyone has any legal questions or DoorLoop questions, Brian will be joining me in a second in the studio. Please start typing them in the questions tab on the bottom, not in the chat, so we can answer them live in the questions tab. And remember, Phil cannot give you specific legal advice. Everything is for educational purposes only. And if you want to speak to someone right now about DoorLoop, if you're a customer or not a customer, just let us know in the chat. Write breakout room, not a customer, or breakout room, I am a customer. And then we can start sending you into private rooms with people from our team that are standing by to answer your questions. So, and if you haven't yet seen it, we ran some surveys and polls and put some links already. So on the bottom, you can see all of them and get some free resources. So Phil, thanks again for jumping back on. Phil, some people in the chat said that your video froze for them at the end when you were giving like your contact information. So if you can, if they want to contact you and reach out for any questions, how can they do that?
Sure. Thanks. Yeah, so the best way to reach out to me or my firm is via our website or via email. We have contact forms on our website, and that's revalaw.com. So REVAH law.com. And again, I just want to be clear, disclaimer to everybody, I'm licensed to practice law in the state of Florida. Eviction laws vary from state to state. It'd probably be very difficult to get a lawyer in who's barred in all 50 states and can tell you the distinction and differences in the eviction laws in all 50 states. But I can freely give advice very generally on particular situations pertaining to Florida eviction law. And then more broadly, if anybody has any questions, just generally as to how to treat, since I'm not barred in any other states, I could give general information about lease agreements just in general and how to deal with tenant just from more of a common sense perspective, not necessarily from a legal perspective.
Awesome. Perfect. Okay, cool. So Phil, I just texted you to your phone a bunch of questions that we have that we're going to start going through right now. And before we do, once again, if anyone has any DoorLoop related questions or wants more information in the chat, just write it and someone can take you into a breakout room. So Phil, first question from the online survey.
Okay.
If a lease has an option to renew monthly at the end of the lease, do you need to do a 14-day eviction notice, or is it better to not have a monthly option?
Okay, so there's no better or worse when it comes to options to renew. It's just something that you could either build into your lease or not. What you want to make sure when it comes to options to renew, and it doesn't matter what state you're in, because like I said, you have the freedom of contract with your tenant. So as long as the provisions of your lease don't interfere with or try to override state laws that cannot be overridden, you can draft for virtually anything in your lease that's not illegal. Now, with respect to an option in particular, if you want to build in an option, you can. In Florida, I'll tell you that it's not common because the Florida statutes say specifically in residential tenancies. In commercial, you could do whatever you want. It's far more wide open. But in a residential tenancy, the rental agreement cannot be for more than 1 year, or it's not governed by Part 2 of Chapter 83, which is the Residential Landlord-Tenant Act. And so what you find people doing in Florida is, they're calendaring the dates that these leases expire, and prior to the lease expiring, they'll reach out to the tenant and they'll say, if you would like to renew, we're happy to renew. We'll send you a new contract for you to sign. I think it's better to do it that way because as a landlord or a property manager, you always want the option. I'm sorry, the screen went blank.
Oh, yeah, I can still hear you.
Okay, I'll keep talking. But you always want the option to...
Yeah, it looks like everyone's screen went blank for some weird reason, but we can all still hear you. Not sure what's happening on Livestorm's end, but keep going.
Okay, sure. So you want the option to, let's say, the tenant is a great tenant for 10 months, and then in month 11 becomes a terrible tenant. Well, if you have built in an option to renew at the beginning of the lease, and you don't want to renew that tenant anymore, now he has the right contractually to renew. So why build in the option when you could just calendar a reminder for yourself and get to it when you want to get to it at the end of the lease, and then determine at that point, do I want to renew this tenant or not? By giving the tenant the option, you're giving them the power to force a renewal upon you. Why do that? Why not just visit that question towards the end of the lease? So generally, residential tenancies, I don't recommend building options into a lease agreement under Florida law and probably every other state's law. An option is a unilateral right given to one contracting party. And so long as that contracting party exercises that right, it then becomes a bilateral obligation. Why do that if you don't have to? And you could just visit the question of renewal at the end. Seems like it's not a good idea.
Okay, awesome. Second question is, what happens if your tenant goes to jail for a few months or a few years? How do you regain access to the property through eviction?
Okay, good question. It's actually happened several times. So like I said before, I gave the example or the anecdote of back in the day when people didn't abide by eviction laws. They just showed up and kicked you out or threatened you under force, right? when a tenant is incarcerated, they're still, the fact that they're incarcerated does not eliminate or invalidate automatically their lease. Their lease confers upon them a right to possess the property. So that doesn't mean they actually have to be in possession. It just means that it confers the right to be in possession.
Right.
And so if you have a tenant that's incarcerated, evict them. Send them a notice, serve them in prison with a copy of the complaint, say you're being evicted because you're no longer in possession. Make sure your lease has a provision that talks about what happens in the event the tenant is incarcerated. You could put the tenant's incarcerated, that's a material default of the lease and grounds for eviction. And then you just follow your lease to complete or commence the eviction procedure, which is, I'll tell you, it's very, from state to state, it's very different. Florida, the laws are very pro-landlord. Okay, New York, probably not. California, probably not. Okay, Florida, definitely pro-landlord. Probably Texas, pro-landlord. Basically, the South, the red states are probably going to be on average more pro-landlord than the blue states. It's just a fact. I'm not making any sort of political disclaimer or statement here. It's just a fact.
Got it. Okay, awesome. All right. The reason it went frozen before, which is going to happen again, is because we're going to be assigning breakout rooms now. So for those that are looking for a breakout room for more information about DoorLoop as a customer, not a customer, we'll be able to assign you there. So stay tuned for 1 second. It's going to probably freeze again. Participants could choose their room. Okay, let's do that. And they could switch rooms. All right, so let's launch that real quick. And while that's launching, Phil, question for you. How long does an eviction stay on your credit history?
Okay, well, I can't speak to other states, but in Florida, a judgment is good for 10 years and then can be renewed for another 10 years, 20 years. And it's unclear to me how the various databases or software handle how they pick the information from the public records and how long they keep them for. So answer to that question, I'm not sure, but rest assured that if there is a judgment against you, that judgment is a public record, or against one of your tenants. It's a public record and it stays there for a very long time. And from my understanding is that companies buy and sell this information or build databases using just the public records that are out there. Court records are public records. They are constitutionally protected public records, whether it's a civil or a criminal case, and the public has access to them. And there are companies and databases out there that mine this information and probably use them in order to do a background search, for example. So not every system is going to be perfect. This is what I understand, but that'll change from situation to situation.
Okay. Next question. Is it illegal to rent 4 bedrooms upstairs at my house? My fiance is trying to evict 4 people who live upstairs at his house, but another lawyer told him that he may have a problem of having multiple units.
Okay, so interesting scenario. Obviously, I need to know what state you're in order to give you any sort of constructive feedback there. But the short answer to the question is, under what conditions and what terms are these people living on the second floor of your home? Is it illegal to rent to them? Well, let's parse that question out for a minute. What are the local zoning laws? Are we talking about a single family home where only one family unit can reside and you're attempting to rent to 4 other people in a single family home where the local zoning laws or local zoning ordinances say that in a single family home, or a single family zoning district, there could only be a single family, and now you've got multiple people. So you got a problem in the sense that maybe you might be violating zoning laws. If you're zoned multifamily, then you got to check what kind of multifamily, right? So
Yep.
maybe multifamily, you can have multiple people there, multifamily, and there wouldn't be a problem with the zoning laws. But what you want to be concerned about is if you take these people to court, they could come in, hire a lawyer, or on their own file one of their defenses could be this entire lease agreement or rental agreement was illegal to begin with because I'm renting out of a single family home in a single family zoning district. And that could be a defense to the eviction. It won't keep them there forever, but it could be a defense, and it could cause the landlord to have to cough up all of
Yeah.
the money that the landlord took in exchange for them living there.
Yep. Got it. Once again, Phil, I don't know if you could see blank on your screen.
Yeah.
Yes.
Yeah, mine's
Yeah. It's the breakout rooms are trying to launch, but Livestorm seems like it's having issues. So we'll switch webinar platforms next time. But let's keep going until it loads.
okay.
So next question says, we have a contract with HRA. What's HRA, by the way?
I don't know if this is a Florida agency.
Yeah, HRA. Yeah.
HRA. It'll depend on the contact.
Yeah.
Yeah.
I'm not sure.
HRA, they could be referring to Section 8, sort of federally subsidized housing. But in Florida, we don't refer to it as HRA. Or it could be some sort of subsidized housing. In Florida, we refer to it just as Section 8 or Housing Choice Voucher Program. But anyway, what's the full question?
So you know what? So the breakout rooms look like they're going to work. I'm going to start them. Let's see what happens. Hold on. Starting the session. The question is, their clients do not pay their rent. They also do not want landlords to evict their clients, but they don't pressure their clients to pay the rent. What gives? What should they do in that situation? I understand.
Right. So I'm not, again, I need more specifics there, but if you have a third party paying for your tenant's rent and you've agreed to accept rent from that third party on behalf of the tenant that's living there, be careful, because they're almost inevitably, those third parties, whether it's government subsidized or whatever it is, are going to require you to abide by their own terms. And then if it's Section 8, there's an aspect of federal law that kicks in and could override state law. So just be careful when you're signing up with third parties that are paying rent on behalf of tenants, low-income housing. Look very carefully at what you're signing, what you can do, what you can't do, because very often they sort of lock you into their terms because they figure they're the ones paying the rent.
Yeah. Okay, got it. Okay. So we have a question from Regeb. We're going to do a live answer. So can you see that question on your screen?
Yes. Changing hand of ownership, honoring previous owner commercial contract. Yes. It says you will join main room.
Yeah, that's fine. Ignore it. This is the breakout room. 3 seconds. Everyone should be able to stay in this room. So let's see. All right, go ahead. You can go ahead and answer.
So honoring previous owner commercial contract to renew a contract. The rent is not meeting the local market. Can I legally double the rent in order to meet the local market? So the mere fact that property changes ownership or changes hands and there's a deed and a closing in the middle of a tenancy does not by itself give the new owner or landlord the right to change the rent. Very often when you buy a piece of property that has a lease in place, a leasehold interest is a kind of interest in real estate. And that interest is inferior, obviously, to ownership. So it's a step down. And so if you buy a property and there's already a lease in place, as the buyer, you become the new landlord and you assume and inherit that lease unless agreed otherwise by all parties. So the short answer to the question is no, you can't legally double the rent. And by the way, there are some markets like New York where there's rent control laws. We have no such thing in Florida. You can't legally double the rent just because of a change in ownership. However, if the tenant is what we call an at-will tenant, like week to week, month to month, no written agreement, it's all verbal, they pay rent on the first of the month, verbal, then because that tenancy is considered at will and can be terminated at any time with a proper advance notice, then you can double the rent. So the question is, you could triple it, you could quadruple it. So the question is, what kind of tenancy is this? Is there a written lease in place? Is there not a written lease in place? If there's a written lease in place, chances are you're inheriting the terms of that lease as the new landlord. If there isn't a written lease in place and it's verbal, then you can give advance notice that you're going to double the rent, and that would probably be effective, at least under Florida law, it would be.
Okay, awesome. Thank you. Nestle had a question here. I'm going to pop it up on your screen.
Okay, you want me to read the question?
Yep. Go ahead.
So legal question. Does it matter if the tenant doesn't pay their rent and have a baby or children they need to take care of and are single parent? Will that affect their eviction? Would they have rights not to get evicted just because they have kids? Is that law different than Florida versus New Jersey? So again, I cannot opine on New Jersey law, but let me tell you that in Florida, the fact if you're a single mom with 50 children, that wouldn't matter. Okay. With respect to eviction, you don't pay the rent, you're probably going to get evicted. If you're literally, I had a case once where I went to court and the tenant showed up in a hospital robe and she told the judge that she was dying. Jury's out on whether that was true or not. And we were evicting her for non-payment of rent. Of course, we didn't know any of this going in. And the judge said, the law requires me to evict you. And the judge's hands were tied because the judge can't do what the law doesn't allow. So the only thing that's going to prevent, at least in Florida, an eviction, if it's a single mother, difficult circumstances, is either A, the landlord's compassion, or B, the filing of a federal bankruptcy, which puts an automatic stay on all lawsuits.
Wow.
And one more thing. Active service in the United States military or any of its allies. That won't prevent an eviction completely, but it'll, at least in Florida, it'll significantly delay how long it takes to do the eviction.
Okay, interesting. Thank you. Next question from Rebecca.
Okay, Section 8 tenant keeps breaking the same things. Her lease is finally up. We gave her 2 months notice of non-renewal. She said she will not leave unless taken to court. Is there any advice dealing with a tenant like this? Section 8 said they can't help at all. Okay, so as everybody knows, or maybe everybody should know, Section 8 is when the government, it's federally subsidized, pays all or a portion of the tenant's rent. Okay. In this case, you have a Section 8 tenant whose lease is up. Under Florida law, I'll tell you what would happen. The day after the lease ends, we would file the eviction in court. And we would say, we are evicting not based upon non-payment. You could evict based upon non-payment, but we would say in that eviction complaint, we would say we are evicting based upon the expiration of the lease. So her right to possess the property, the leasehold interest, has expired. And that is a ground in and of itself for eviction. Now, maybe there are other grounds for the eviction. Maybe she's committing illegal acts at the property. Maybe she hasn't paid the rent. Well, you can tack all of those things onto the eviction suit, and then you can get in front of the judge and say, Judge, I have multiple grounds for evicting this tenant, and each of them on their own is sufficient to get a final judgment of eviction.
Got it. Awesome. All right. Thank you. Anna had a question. Go ahead.
Okay. Question. Tenant said in writing she moved out at lease end, but left items behind. We asked her to return for them. No response. We remove them ourselves. Are we liable for disposing of her belongings after a written move out and no reply? So again, we went over this during the Q&A. This is kind of like the hypothetical situation. It wasn't even hypothetical, it was actual situation that I gave in a case that I'm dealing with. If a tenant moves out and she says in writing she moved out, and then you go to the property and you figure out that she left items behind, I, as an attorney, would advise my client, regardless of what she put in writing, to do an eviction. Why? Because while she might not be in actual possession of the property, the law considers her leaving her things behind as being in constructive possession of the property. And the last thing you want is 6 months from now or a year from now, this tenant who could be an opportunist, to hire an attorney and sue you for throwing out her belongings. And then your defense, of course, is going to be, well, she said in writing that she moved out. We asked her in writing to come back for them. She never responded. That could be a defense, but do you really want to risk that defense at trial? A judge or a jury could disagree with you on disposing of her belongings. So in a situation like that, where the tenant leaves things behind, at least under Florida law, I always advise my clients to sue for eviction because the tenant is still in constructive possession of the property.
Got it. Okay, awesome. All right, here is the next question from Shiv.
Next question. Tenant leaves after hearing the eviction order, but tenant owes rent. In such a case, how to get the rent amount due? Okay, so I'll tell you how it works under Florida law. So a lawsuit for eviction is different than a lawsuit for breach of the lease money damages, right? So suing for eviction is a suit for possession of the property. Suing for unpaid rent is a suit for breach of contract for unpaid rent. 9 out of 10 landlords that call me say, sue for eviction only. I don't even want to go after the unpaid rent judgment because I know that even if I get that judgment, I'll never be able to collect it because this tenant is on subsidized housing and doesn't have any money, right? And so the answer to the question is, how do you get that rent amount? You got to file a separate suit, a non-eviction suit for breach of contract money damages. You could probably file it in small claims if the amount is low enough. But otherwise, you file a separate suit for it. The trick here, though, is that when you sue for money damages, you have to personally serve, at least in Florida, the tenant with the court papers, meaning a process server has to go and physically deliver the lawsuit to a tenant.
Wow.
If you're unable to personally serve, then the court will never acquire personal jurisdiction over the tenant, and you'll never get a judgment for money. Okay. Remember what I said earlier during the initial Q&A. When you're suing for eviction, you don't need to personally serve because you're suing the property. You're suing for possession of the property. There's a legal fiction going on where, in part, you're suing the property. Okay. And so you don't have the issue of having to personally serve when you're suing for eviction only. But once you add a count for money damages to an existing eviction suit, or you separately file a money damages suit, you have to personally serve. It takes a lot more time. And then, of course, there's always the issue of, I got my $10,000 judgment for unpaid rent against the tenant. The judge signed off on the judgment. Here it is. It says the tenant owes me $10,000. Great. Now you have a piece of paper that says that somebody in the world owes you $10,000. Go collect it. And to collect it, you got to do asset searches, freeze bank accounts, get break orders. You can't, most of the time, if these people are low income, you're never going to collect the dollar. And so why spend the money on an attorney and on court costs if you're not going to collect? And that's just the reality of our legal system. I mean, it's just a fact.
Yeah. Okay. Awesome. Thank you. Let's mark that as done. Okay. Next question. Go ahead from Tamika.
Okay. Tamika, tenant received the final stay stipulation for the end of May. Can a judge come back and change a final stipulation, asking for more time if a tenant cannot find housing? Okay. So this is a very broad question, and it's impossible for me to answer it. And the reason why it's impossible is because, at least with any specificity, is because I need to be able to get into the case. First of all, I need to know, is it a Florida case? Is it some other law, state law applying? I need to get into the case. I need to figure out what's going on in the case, right? So right off the bat, I tell you I can't answer the question. But what I can say is that you want to look at the terms of what the judge wrote and try to make the best argument you can that the tenant can't get more time because it goes against what the judge wrote.
Got it. Awesome. Thank you. Here's one from Frankie.
Question: if a tenant is behind on rent and makes a partial payment, can the eviction process continue? Okay, well, the question is, who did the tenant make the partial payment to? Again, I can only speak to Florida law. So, but I imagine it's generally the same across all states. If the tenant is behind on rent and makes a partial payment and the landlord accepts that partial payment while there's an eviction process in court, many state laws say that the landlord waives the right by accepting the rent to continue with the eviction, because that behavior of accepting rent is inconsistent with the thing that the landlord is suing for, which is possession of the property. And so my advice is, once you commence an eviction proceeding, I don't care what state you're in, don't accept any rent. And if your state is the kind of state that requires the tenant to go to the court to deposit the rent into the court registry, then direct the tenant to do that. Don't touch the rent once the eviction process is underway.
Awesome. Okay, thank you. Next one from Yaz. I'll throw it up.
Question: tenant said in writing there will only be 3 people living the property. Have she brought in more people to the property? Can I raise the rent or ask her to move out because she broke the lease clause? Certainly. So, again, depending on what state you're in, if you're in Florida and the lease says a maximum of 3 people will be living in this property and here are their names, ages, and social security numbers, right? And then you find out that there's a 4th, which, by the way, requires good proof. You might want pictures. Maybe there's a car parked outside that's tied to a fourth person. It's hard to get proof sometimes. Sometimes you can just get them to admit it, right? But anyway, assuming you get that proof, then you give the tenant a notice and you say you're in violation of the terms of your lease. You have X amount of days to remove this unauthorized occupant from the property so that you're no longer in violation of the lease. And if they don't, then after that time period is up, you go ahead and file the eviction suit in court.
Got it. Okay, awesome. Here's one from Raynette.
Right, question. If a lease specifies that it will automatically convert to a month-to-month tenancy at the end of the term, but the landlord does not want it to continue on a month-to-month basis, can the landlord end the lease by giving notice before the lease expires? Okay, the short answer is yes. You should always give notice. The more advanced notice you can give, the better. Notice that's too short prior to the, you got to look at the lease, obviously, but notice that's too short will not be effective under some state laws, at least under Florida. So make sure you follow the letter of the lease exactly to a T, and make sure that if you don't want this tenancy to convert to month, that you give at least, I would say at least 60 days notice before the lease expires. But then again, I don't know, maybe the lease says you can give at least 15 or 5 days notice. You got to check the lease, but give advance notice that you're not going to be accepting a month-to-month tenancy and the lease will not be extended.
Awesome. Okay, here's one from Simona.
Oh, question. Between a bank levy and a wage garnishment suit, which route is the best to ensure greater success in recovering funds? In this case, we have two separate evictions. One tenant owes a little over $20,000 in damages and unpaid rent, and the other owes $10,000 in damages and unpaid rent. So this question assumes that you have obtained a money judgment against both of these tenants. And assuming you have that judgment, you're now undertaking collection efforts to collect that money judgment. And it's asking what's the best way to go about collection efforts? A bank levy, meaning freezing their bank account, literally having the court take money out of there, or go toward their employer and send them a writ of garnishment and then take a portion of their paycheck every week to satisfy your judgment. So, and it says which route is best. As far as I'm concerned, any way that you can collect, do it. So if that means levy the bank, wage garnishment, show up, knock on their door, literally take their furniture out. I mean, I don't know, you can get very creative with this, right? So, if you have a judgment, execute it in as many ways as possible.
Awesome. Okay, thank you. Let's go to Farid.
Okay, question. Significant other, parentheses, boyfriend, that is not listed on the lease has the right to be in the property after Tangent has evicted property during an early termination of the lease. At this point, tenant has already moved to a different state with forwarding address given 60 days notice of early termination. So I think what this is saying is that somebody let their boyfriend into the property, and then that person who let them in left, and now the boyfriend continues to live there. Well, be careful. The landlord can evict both the boyfriend and the person that is in the property, and the person that is no longer physically in the property, regardless of whether they gave notice. And the reason is because the boyfriend came into possession of the property through the named tenant. So in that case, you would want to evict both.
Okay, awesome. We have a question in the chat, and for everyone that's still in the chat, please go to the questions tab and ask the question there so we could pop it up on Phil's screen. So in the chat, Harry asked, and you mentioned this earlier, can we use AI to do legal work, and which AI do you recommend?
Okay, so as a lawyer, unfortunately, I do not recommend any AI. It's against my pecuniary interest, right? Like I said, AI is a tool that is specific to, as far as I'm concerned, like ChatGPT or Grok, right? And those are the two that I mentioned earlier. You want to make sure that you know what you're talking about when you ask AI a question. The answer is only going to be as good as the question, right? So if you're an engineer or an astrophysicist and you go to ChatGPT and you say, tell me the distance between the moon and the sun, and how big is our galaxy, and how long have we been here for, and why are we on a rock floating in the middle of nothingness, okay? If you're an engineer or a cosmologist or an astrophysicist, you know how to ask questions that are more particular, more specific to the kinds of answers you want AI to give you. And the better your question is, because you have all this background knowledge, the better the answer is going to be. The same thing goes for lawyers. So like I said before, lawyers are, as a tool for lawyers, it's a great tool because you can ask the right narrow question and get a narrow answer, knowing all of the background information, and you're able to synthesize that information properly and use it. But if you're a non-attorney trying to learn law from AI, bad idea. You're almost inevitably going to get out. Can you learn like basic stuff like, hey, I have a tenant that has 14 cats, and I live in, and the tenant's property is in Nebraska, and I need a step-by-step on how to evict this tenant, what kind of notice to give, what should the notice say, how should it be delivered, right? Now you're asking a really good question to AI. And AI is going to pull up Nebraska law. It's going to give you a step-by-step. It's going to tell you what kind of notice you should give, how you should give it, who should give it, right? But if you're somebody that says you go on AI and you say need to remove family member from property in California, please help, you're not going to get a good answer. So again, it depends on the knowledge and all the built-in assumptions of the user operator. And be careful with AI. Like I said before, run it by a lawyer before you take its answer as gold.
Okay, awesome. All right, we've got Simona. Here we go.
Wait, question. When posting a notice on a door, I've been instructed to take a picture of the envelope. However, should the notice be posted open and contents shown to avoid the argument that the tenant did not receive that notice? Yeah, so the answer is yes. Anything could be in the envelope. And if a good lawyer, tenant gets a good lawyer, they're going to go to court and say, there's no proof that the notice he is now presenting to you, Your Honor, is the notice that he posted on the door. All he posted on the door was an envelope. We don't even know if anything was in it. So, yes, post a notice and show its contents. Now, some people in the chat earlier were saying, well, I always post a notice and I text it and I email it. More power to you. Go for it. Do all of the above. But make sure you comply with your state laws, because typically the state laws will say, look, doing all this extra stuff like texting and emailing is good, but you are required to do at least one of the following, which is post, certified mail, or hand delivery. For me, the best thing is post. You got proof that it's on the door. You got a picture of the door. You got a time-stamped photograph. The photograph has metadata in it, which tells everybody when it was taken. Nothing better than posting and taping to the door, at least under Florida law. And I say tape to the door, but sometimes the properties get tricky. There is no door. It's a farmland or something, right? So the statute actually says post at a conspicuous place on the property. So maybe if you're evicting an agricultural tenant and there's a gate that you have to open and drive through onto the farmland, you're going to, I don't know, go buy a poster, 5x5 cardboard poster, tape it.
Rent a billboard on the highway.
Right. Yeah. Put a billboard on the highway. Right. So, send a carrier pigeon. Not a good idea. Okay, we don't know if it'll, unless you have the ones from Harry Potter, they know exactly where they're going. Not a good idea.
Okay. Awesome. All right. We had a question. I can't put it up on the screen, but from Meg, who asked, is there a difference in the eviction procedure if the owner of the condo is a private person or an LLC?
Okay, so if the owner of the condo is a private person, meaning an individual plaintiff, at least under Florida law, that person can file their own eviction. Obviously, bad idea. That never ends well. I can't tell you how many calls I get from people who try to take the law into their own hands and then they end up getting a lawyer and it costs 10 times more. But anyway, so is there a difference? Yeah, the difference is that the named plaintiff in the case or petitioner is going to be the person, if the person owns the property, or the LLC or corporation, if the LLC or corporation owns the property. Now, I will say under Florida law, an LLC, a corporation, a trust, a partnership, whatever it is, any legal entity that is not an individual person must be represented by an attorney. It may be the same in other states. It may not be, but in Florida, if an LLC owns the property, must be represented by an attorney.
Okay, awesome. All right. we have a few more questions coming up. If anyone listening still, there's a lot of people actually still here, go to the questions tab, ask Phil your questions. We got about maybe 10 more minutes left, so ask away. And for everyone else, if you have DoorLoop questions and you're either a customer or not a customer yet, I am going to post again in the chat. We have 2 Zoom rooms right now set up for you, so you could join now or after, whenever you want. And people from our team are waiting for you over there. Cool. Next question. I'm going to put it up on your screen from Christine.
Okay, question. If tenant gave advance notice 2 months that they will not renew their lease, and 3 weeks before the lease expires, they are asking to extend to a month-to-month extension, is this automatic, or can the landlord decline? Can they get evicted if landlord declines? So no, nothing's automatic unless the lease says it's automatic, right? Again, the lease is the document. It's a contract. It is you consider it the Holy Bible for your purposes as a property manager or a landlord. Everything that should ever transpire between a landlord and tenant and their relationship with respect to a property should be memorialized in the lease and accounted for in the lease. So if the lease doesn't say it's automatic, it's not automatic. The landlord can decline, especially since the landlord relied upon the tenant's representation that they were not going to be renewing, and then 2 weeks before the lease ends, the tenant changed their mind. Landlord might have said, hey, I already rented it to somebody else, or whatever the case may be, right? So they can get evicted, yes, for remaining in possession past the natural term of the lease.
Got it. Okay, awesome. Thank you. And we got one from, a bunch just came in. All right, let's go down to the bottom. So Kathy wrote, not a question, a piece of advice we received was to go to eviction court and just watch and learn. You can learn a lot from being in the courtroom. Agree?
Absolutely. It's probably more entertaining than TV. Do it in person. A lot of people don't have the time on their hands, but nowadays I think some judges even have open Zoom where you don't have to physically go to the courthouse anymore. So you want to participate as a member of the public in watching 500 people get evicted on a typical Monday morning. Like I said, more power to you. Go for it.
Awesome. Phil, by the way, I think you're out of frame, so maybe shift back into the middle. There we go. So I threw up another question from Hiram. Go ahead.
Okay, question. With respect to Florida law concerning the mailing of the notice of intention to impose claim on security deposit, same states to mail to tenant's last address, which should presumably be the leased premises. Where should the notice be sent to comply with the statute? Okay, excellent question. I feel like I finally respond something on point. So Chapter 83.49 of the Florida statutes governs the landlord's required handling of the security deposit. And it says that if the landlord intends to impose a claim on the security deposit, then he must send a notice of his intention to the tenant's last known or current mailing address, if he has it, via certified mail return receipt requested. Well, let's say that the tenant made a ton of damage in the property. Landlord's getting ready to whack the security deposit for everything and then some, right? But the tenant is so savvy that he knows that the landlord will never be able to personally serve him with a money damages lawsuit, and he doesn't want to give up his whereabouts. So he doesn't want to tell the landlord where his new place is, what his new address is. And very often they don't want to tell the landlord, and they don't. And so the landlord, the law is smart. The statute accounts for it, and the statute says if you don't know the tenant's current mailing address, or if they're not giving it to you, then you fulfill your obligation as far as making a valid claim on the deposit by sending it to the tenant's last known mailing address, certified mail, return receipt requested. And so long as you do that, you're good to go. And if they try to say you didn't send the required notice to me, you're going to say, actually, I did. I sent it to the last known mailing address because when I asked you for your current mailing address, you didn't give it to me, or you ignored me, and you didn't want to give us your whereabouts. So we complied with the law and sent it to the last known mailing.
Got it. Okay, awesome. So Adam has the latest question. Go ahead.
Okay, question. Can a separate document in addition to the lease state more clauses to protect the landlord if the lease itself does not address it? Okay, this is more to do with contract law than landlord-tenant. Can a separate document in addition to the lease? So you're talking about an addendum or an amendment to the lease, right? Because the lease is the document that governs the rights and obligations of the landlord and the tenant. And so if you have a separate document that's adding clauses, it's probably an addendum or an amendment. And in every case, an addendum or an amendment to a lease must always, in that addendum or amendment itself, it must always refer back to the lease. So you'll have a clause at the beginning of that addendum or amendment that says, this addendum or amendment is expressly incorporated into the terms of that certain lease that was executed by and between so and so on such and such date. And so long as you do that, yeah, you can add 20 million pages of clauses, assuming you guys want to sign 20 million pages later on.
Got it. Okay. So going back, we can go to Jacqueline. Go ahead.
Okay, question. I forgot to file a 3-day eviction on the 4th day. Can I file it on the 5th day, or does the 3-day process need to start over? Okay, so again, I don't know what state law this is, but what I think this question is referring to is this person has given a 3-day notice to the tenant, and those 3 days have expired. And on day 4, we're talking business days, and on day 4, they forgot to file the eviction. Can they still file it on day 5 or 6 or 7 or 8? And the answer to the question is yes, you can, so long as you have not, if you're dealing with Florida law, so long as you have not accepted any rent, any partial rent, since the date of the posting of the notice. It doesn't matter. You could file it 2 months later if they haven't paid any rent from the date of the posting of the notice.
Okay, great. Thank you. So next one, I don't know if this is a question. Go ahead from Michelle. No, not a question.
Okay, yeah, it's a statement, and basically it sort of confirms what I said earlier, which is that in Florida, an LLC or legal entity, corporation, partnership, et cetera, must be represented by an attorney. And I guess this person is saying that in New York, it's the same thing. So good to know.
Okay, awesome. Thank you. And here we go. Arthur asked this question.
Do you recommend to have a new lease every year or just to have an addendum to extend the lease? I recommend a new lease every year. The problem with addendums when they're not being done by an attorney is that they tend to become confusing and ambiguous because they start mixing documents together, and then you have to go and backtrack and see if the former document conflicts or is consistent with the new document. I would say residential tenancy, obviously commercial leases can be 5, 10, 15, 20, 99 years, right? So we're talking only residential here. And residential, I would say always get a new lease every year and just follow up with your tenants before their lease expires and say, hey, you've been a good tenant. We want to offer you a new lease. It's going to be generally the same terms, except we're going to tweak your rent a little bit, or we're going to tweak this or tweak that. And have them sign a new lease because it just keeps things very clean and organized and no confusion when it comes to the attorney.
Got it. Okay, Randy asked, do you have a fixed price to file a commercial property eviction that is not anticipated to be contested?
The answer is yes, I actually do. So, if it's a commercial, if it's not contested, that's the key phrase, right? So as an eviction attorney in Florida, if I file an eviction against a commercial tenant for non-payment of rent, I know pretty much where my work is going to begin and end because there are these default mechanisms in the Florida statutes that allow me to make very good guesses about how much work I'm going to put into the case. But if the case is contested, right, now I don't know where my work begins and ends because maybe the tenant got a lawyer and these are two sophisticated landlords and tenants in a commercial property. I represented a landlord in an eviction case against a tenant. They were renting 50,000 square feet in Orlando, and they were selling batteries. Okay, there was a non-payment of rent eviction, believe it or not, but it was very difficult. And the tenant got high-powered legal counsel. And they had the money to pay for it. Right, wow. That's not always going to happen in residential context. So.
All right, next question by Shiv. Go ahead.
No, a notice should be served by constable or can be done by landlord property manager, ? Any advantage to a constable serving it? Should it be 14 days notice minimum in Massachusetts or less?
And also help everyone understand what is a constable.
Okay, so So first of all, Massachusetts, right? So I don't practice law in Massachusetts, cannot opine in Massachusetts. In Florida, we use no such words. It just proves to you that Florida is like a new addition to the USA, and Massachusetts has been around since the time that, you know, we got our independence from the United Kingdom. I imagine that what he's referring to when he says constable, because we literally never use that word in Florida, is a process server, meaning somebody licensed by the state to serve legal process on people being sued. And the answer is, you don't need a process server to serve legal notice. You can get Joe Schmo, your neighbor, to serve it if he agrees to act as your agent for purposes of serving the notice. I would say learn how to do the notice yourself, run it by a lawyer before you ever post it. Maybe you have general counsel, and do it yourself and save the money, because a constable or a process server, they're going to charge you 85, 95, 150 bucks every time they go out there. And for what? Just to post a notice? Maybe the guy pays the next day. You know, maybe you post a notice and he finally pays. So why spend that money?
Got it. In the chat, Michael wrote, can someone place something in the rental agreement that does not actually give the tenant possession, so you don't have to actually go through the possession process?
I'm sorry. Michael wrote what now? I don't see it on my screen.
I'm gonna throw it. I can't put it up on the screen. I threw it in the chat. Can someone place something in the rental agreement that doesn't actually give the tenant possession, so you don't have to actually go through the possession process?
Okay, so I think what he's saying is there a way to avoid the eviction process if you have a tenant that's in default of the lease, meaning avoid going through the courts? And the answer is no, as far as I know. No, if you have a tenant that's in actual or constructive possession, in order to legally remove them, you have to go through your state's eviction process.
Okay, got it. Oh, yeah, and just to go back to that previous question from Randy before, so what is the fixed fee to file a commercial property eviction that's not contested?
In Florida, it's $1,500. That's the attorney's fee. That does not include the cost of suit. That's at least what my firm charges. You probably have different fees from different lawyers. So, you know, some lawyers, if you go to Greenberg Traurig, okay, the high-powered international law firm, they're going to ask you for a $25,000 retainer before you step through the door. All right.
Yep.
If you call a guy, an attorney, a small boutique, medium-sized firm that specializes in evictions, you're probably going to get a flat rate or something very different, right? So every lawyer has their rates and whatnot.
Perfect. Next question comes from Frankie. Go ahead.
Question: if we need to return a security deposit but don't know where the tenant moved to, what do we do with it? Okay, so Florida law, like I said earlier in response to a different question, accounts for that scenario where you need to return the deposit, but the tenant's not communicating or giving you their new mailing address. Florida law says send it to the last known mailing address, return receipt requested. I can't tell you what other state laws say, but that's always a good idea.
Okay, cool. Next question, about maybe 4 or 5 minutes left. Tabitha, go ahead.
Yeah, can you elaborate on rental suitability certificates? When and how often does it need to be given to a tenant? I'm in Pennsylvania, so I can't elaborate on a rental suitability certificate because there is no such thing in Florida, and I'm only licensed to practice law in Florida. If it has to do with the suitability of a tenant, I guess maybe there's some third-party agencies that issue certificates that say, hey, this person, they're suitable to be rented to. If that's the case, great. I guess take advantage of that resource. We have nothing like that in Florida.
Okay, awesome. All right. And I think maybe the last question here. Is it a question? Let's see.
Question, Knoxville, Tennessee. We had stipulations written into the lease in special stipulations. Tenant is saying that Tennessee law supersedes what is written in the special stipulations. Is this correct? Or are the special stipulations also viewed as part of the official lease? This is a very deep question, okay? What he's saying is, remember what I said earlier, you have the freedom of contract, right? But you can't contract, me and you, David, are going to rob a bank and we're going to split the proceeds 50-50. So we rob the bank. Sure enough, we get $100 million. We're about to move to Thailand. I'm the one with the money in my truck. And you say, hey, give me my half. And I say, no, our contract was illegal to begin with. You can't enforce it in court. Well, I would be right. Okay, you can't go to court, sue on an illegal contract. And that's what this question is asking. Can I write special provisions or clauses into my lease that conflict with statutory state law? And the answer is typically the law will itself, the statute itself will say this cannot be overwritten by agreement between the landlord and tenant. If it says that, there's your answer. If it doesn't say that, you can argue in court, and maybe you'll make some case law that there is freedom of contract and that the parties agreed on it. And then the argument becomes, well, can this freedom of contract override what it says in the statute? And to answer that question, you analyze the contract, you analyze the statute, and you make your argument to a court.
Got it. Awesome. Okay. Okay. Yaz asked, where in Florida are you specifically located?
Okay, so we have offices in the Tri-County area, but like I said at the beginning, we do evictions statewide. If it's an eviction matter, it's in all 67 counties. A lot of Florida courts are now moving, I wouldn't say a lot of, during COVID, everybody moved to Zoom. So now a lot of eviction court is on Zoom. A lot of judges are still old school as well, especially in the middle and northern part of Florida, and they want you to come into their courthouse because they refuse to use Zoom. But more often than not, you'll get a Zoom hearing if you ask for one, especially if you're out of county. So,
okay, great. Viviana, go ahead.
Question, if we need to take the last month rent from the deposit since they didn't pay, do we have to send a letter to the tenant indicating that? So in Florida, definitely, right? Your obligation as a landlord to send a notice to the tenant telling them what you're going to take out of the deposit, the security deposit, and why applies regardless if they pay the rent or not. So paying the rent has nothing to do. You send that letter and you cover your bases, because the last thing you want to do is get sued by one of these lawyers who's just looking for this low-hanging fruit to sue the landlord that they know is collectible.
Yeah. Okay. Awesome. We have one from Marlene, but I don't know if I understand the question. Even if last known address is the rent property, what if last known address is the rental that they moved from my place? I think it might have been in regards to a previous question.
Yeah, that's always the case. Yeah. The last known address is always the place that they moved from, your place. That's always the case. And it's their job to forward their mail, or at least that's what the law seems to imply. So if they won't give you their current mailing address and their last known is the place that they were renting from you, then that's okay, because the law sort of imposes some kind of an obligation to send it somewhere. And as long as you have proof that you did that within the time period required by your state's laws, you're good.
Okay, awesome. Thank you. And I'm just going to push up this survey right now. If you haven't taken it yet, I'm putting it on your screen. Just please help us for future webinars. What do you want to see in future webinars? We have one coming up we're going to be promoting soon. You'll see it on accounting. We're going to bring a CPA in to answer all of your accounting questions. So next question from Arthur. Go ahead.
Question, just to confirm, you take money owned from deposit as long as there is notification that we are doing that. Anytime you take a claim, you make a claim on a tenant security deposit, that claim should follow your state's laws. It should be in writing. It should be sent certified mail return receipt requested. And if you have the additional ability to send it in more than certified mail fashion, maybe your state only requires certified mail, but if you have the ability to send that written notice of claim on the deposit via mail, email, carrier, pigeon, fax, you name it, do it.
Okay. Pigeon and fax, love it. And we did have a few people that were interested in DoorLoop in the poll, and they're asking us questions here. So if you do want a demo of DoorLoop or want to see any more information about DoorLoop, you can just go to doorloop.com and schedule a demo straight from there. And I will also be posting it right now here for you that you can see on your screens. Cool. All right. Go ahead from Christelle. Next one.
Okay, I'm sorry, I didn't hear the answer regarding special stipulations. In GA, that's what's used instead of an amendment. Okay, so I can't opine as to GA law, but the answer was that typically the law itself will state you cannot override this in a lease. Like, for example, maybe the example is in Georgia, you have a lease that says tenant waives the right to receive any notice of the claim on the security deposit. and then the tenant sues the landlord and says, hey, the lease has this clause, but your honor should find it invalid because it doesn't comply with Georgia law, then you would make your arguments back and forth.
Okay, awesome. Okay, and we're going to make this the last official question for today. So go ahead from Viviana.
Okay, question from Viviana. In Florida, if a person is living in a property and she is not in the lease contract, how can I evict her? She is receiving mail under the name already at the property. Okay, so there's this misconception that just because somebody receives mail or their driver's license is at the property, that somehow means something legally. It doesn't. In Florida, if somebody is living in a property and she is not on the lease, the way to remove that person is to remove the named tenant and her, whoever that person is, him or her, right? You have to remove the named tenant in the lease because it is the named tenant that is allowing that person or that allowed that person to come into possession. And now in order to effectively remove that unwanted person, you have to remove the person in the lease because they came into possession by, through, or at the direction of the tenant that is on the lease. And if you try to evict just the person that's not on the lease, then the person that is on the lease could keep letting them back into possession. Like that's what keeps, so you don't keep filing eviction suits. Doesn't make any sense.
Okay, awesome. All right, Phil, we did it. Thank you, everyone. Phil, so generous to be on here for almost 2 hours now. Thank you so much. That's Phil. You're right. Always happy to help. He just loves helping people. So if you have any questions for Phil or need his help in Florida, please go to his website at revalaw.com. I'm going to post it now in the chat.
Appreciate it.
And okay, there you go. Everyone's saying thank you, thank you. And if you are a DoorLoop customer or not a DoorLoop customer, after this, in the next 30 seconds, I'm going to be posting 2 more links in the chat. So you could join our Zoom rooms. We have Zoom rooms right now open, breakout rooms with people from our team waiting if you have any questions. So I posted that here. And we have an accounting webinar coming up in a month, so be on the lookout for that. Phil, any last remarks? Anything else you want to throw in there?
Yeah, guys, just, good luck. Keep a lot of contact with your tenants. Do it all through a good property management software, like I'm sure you're going to be doing already through DoorLoop. Keep it all in a centralized location. Keep track of all your communications. Keep track of your tenant's ledger. And so long as your document is in order, your paperwork is in order, you'll always be in good standing if you have to go to court.
Awesome. Thank you, Phil. And everyone else, you are going to get an email in the next hour, probably automatically, with the recording and a few resources and links. And that is it for today. Thank you, everyone. Thank you, Phil. And we're going to end it now. Bye, everyone.
All right.